If you have two separate lawsuits that arise out of the same transaction or occurrence, or a series of transactions or occurrences, or that have a significant element in common, such as a question of law or fact in common, then pursuant to Rule 6 of the Rules of Civil Procedure, you could potentially obtain a court order to consolidate or join the two legal actions together, or have them heard at the same time or immediately after the other. However, Rule 6 does not provide any guidance as to what factors the court might consider when faced with a debate about whether to consolidate proceedings or to order them tried together. The jurisprudence is not particularly helpful either. In this episode, I'll explore those factors that a court would consider and explain the difference between the options of consolidation and hearing together. Stay tuned. And welcome to the 5th episode of Season 2 of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual solo and small firm conference, and the founder and owner of my law firm, Rudder Law Group. For as long as human beings have been actively engaged in the pursuit of justice, we've experienced delays, hurdles, constraints, and expense. Even now in 2024, access to justice in civil cases is still a matter of consternation for all justice system constituents, where delays and expense are still acute problems. The supply of judicial resources is limited in relation to the heavy demand on those resources. There's always an ongoing need to utilize the court's limited resources as efficiently as possible. So, adjudicating multiple legal actions arising from the same set of circumstances generally does not serve the aim of efficiency. For that reason, Section 138 of the Courts of Justice Act provides that a multiplicity of legal actions is to be avoided as far as possible. In this vlog, I'll be discussing Rule 6 of the Rules of Civil Procedure, which allows the court to consolidate or join multiple legal actions, or order that they be heard at the same time or immediately after the other. The underlying rationale behind Rule 6 is to save expense, avoid multiple pleadings and legal actions, and avoid inconsistent judicial decisions. In the absence of Rule 6, closely related legal actions could produce different results if heard by different triers of fact, such as a judge or a jury, and could lead to increased cost and a waste of resources. A good example is where liability is an issue in two personal injury legal actions that arise from the same motor vehicle accident, and there is the possibility of having inconsistent results in the determination of which one of the defendants caused the accident. So where multiple cases have common parties, facts, issues, witnesses, transactions or occurrences, lawyers and/or claims for relief, the court may join the legal actions. However, the court must consider fairness and delay and balance the interests of expediency and convenience with possible prejudice to the parties. The court balances these interests via what is known as the balance of convenience, which is a common law test, where a court applying this test will balance the prejudice of one party of denying the relief asked for against the prejudice to the opposing party if the relief is granted. Consolidation and hearing together are different procedural remedies which may accomplish the same goal, but in slightly different ways. The differences were described by Justice Quinn in a 2008 case entitled Wood and Farford Limited as follows, quote, "Where two actions are consolidated, they become and proceed as one action. Thus, there is one set of pleadings, one set of discoveries, one judgment, and one bill of costs. If two actions are ordered to be tried together, the actions maintain their separate identity, and there are separate pleadings, discoveries, judgments, and bills of cost. But the actions are set down on the list one after the other to be tried in such manner as the court directs. Usually, the trial judge will order that the evidence in one action is to be taken as evidence in the other action or actions. In this way, both or all of the actions are tried together by the same judge or jury. Although it has been said that the difference between consolidation and an order directing the trial of actions together is more technical than real, I think the difference can be quite real if the matter is addressed promptly. Actions ordered tried together largely offer a savings of time and money and enhanced convenience at the trial stage. However, consolidation provides those features from an earlier stage in the proceedings, including one set of pleadings, affidavits of documents, discoveries, and pretrial memorandum, and one pretrial." End quote. So consolidation involves combining two or more proceedings into one, with one set of pleadings, one set of discoveries, a common pretrial conference, and a single trial. The underlying rationale for consolidation is that it helps to serve the goal of efficiency and limits the risk of inconsistent decisions. It also avoids multiple actions going ahead at different speeds or timing. However, it does require the redrafting of pleadings, as one set of fresh consolidated pleadings is required. An order for consolidation is generally deemed to be more appropriate when the proceedings are at an earlier stage in the litigation process. If you do obtain an order to have the legal actions heard together, then the proceedings keep their separate identities, but they are either heard or tried together, or one after another in series. It's also important to remember that the proceedings must be in the same level of court, for example, the Superior Court of Justice, and in the same region, plus the same trier of fact, such as a judge or jury. Lastly, the test for consolidation is stricter than the test for hearing together, because consolidation involves the reconstructing of two or more legal actions into one legal action. On the flip side, an order that multiple legal actions be heard together, or one after the other, also protect against inconsistent findings. But it differs from consolidation in that it does not require one set of pleadings or discoveries, or a single pretrial conference or trial. Other key differences are that it does not protect against the risk that the multiple legal actions will proceed at different paces, nor does it provide for the sharing of evidence among all parties to the legal actions. However, a judge in the Superior Court of Justice has the discretion to make additional orders to address these issues, such as, for example, an order requiring common discoveries and for all parties and all actions to exchange affidavits of documents. The judge can also order a common pretrial conference. In some cases, the court may use its discretion to proceed with a hybrid approach by endorsing an order that multiple legal actions be heard together or one after the other, but consolidating either the discoveries and other pretrial steps, or one or more of the issues. We see this, for example, in cases where there is a common liability issue between the legal actions because they both arise out of the same motor vehicle accident, but the other heads of damages being claimed are different. This can happen in a personal injury case where, for example, two legal actions arise from the same motor vehicle accident, but one legal action is a Family Law Act claim commenced by the surviving family members of a deceased passenger in the vehicle, and the other legal action is commenced by a person who sustained injuries from the accident. So let's break down Rule 6 some more. Pursuant to Sub-Rule 6.011A, a judge may grant an order for consolidation or hearing together if the legal actions have a significant element in common, such as a question of law or fact in common. Pursuant to Sub-Rule 6.011B, a judge may determine that either consolidation or hearing together is appropriate if the relief being claimed arises out of the same transaction or occurrence or series of transactions or occurrences, such as the same motor vehicle accident. Pursuant to Subrule 6.011C, an order may also be made for any other reason that such an order ought to be made. So a judge is provided with wide discretion to consider other factors in making an order under Rule 6. This includes giving any directions that are just and fair to avoid unnecessary cost or delay, such as, but not limited to, abridging or shortening the time for placing an action on the trial list. Pursuant to Subrule 6.01EI, a judge is also granted with the power to stay related legal actions pending a determination, such as the decision or ruling in any of them. In order to stay a legal action is in order to suspend or postpone all or part of the legal action or trial. In the spirit of the aforementioned principles of fairness and efficiency, a Rule 6 stay of one or more legal actions may be deemed appropriate in order to allow a related legal action to catch up or to allow a transfer from one jurisdiction to another. However, prior to granting an order to stay a legal action, a judge will balance potential prejudice, including but not limited to greater cost and delay. Pursuant to Subrule 6.01EII, in order to consolidate legal actions, a judge is granted the power to order that one proceeding be asserted as a counterclaim in another, so as to limit the risk of inconsistent decisions. A counterclaim is an opposing claim in a legal action. There are some other relevant rules that the court must be mindful of when exercising discretion under Rule 6. The first one is Rule 1.041 of the Rules of Civil Procedure, which captures the underlying principle for the court to consider as it directs the court to interpret and apply the rules so as to, quote, secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits, end quote. Rule 6 does this, of course, by helping to save expense, avoid multiple proceedings, and consider fairness and delay. Secondly, the court must also be mindful of the provisions and underlying principles of the Courts of Justice Act, such as the aforementioned Section 138, which provides that wherever possible, a multiplicity of proceedings shall be avoided. The court must also be mindful of the aforementioned Section 107, which permits consolidation where the legal actions are in different levels of the court, as well as a transfer of one legal action from a different region so the legal actions can be heard in one court. If a jury notice is filed pursuant to Rule 47 of the Rules of Civil Procedure in one legal action, but not another, then the court must carefully weigh the aforementioned principles under Rule 6 against the right to proceed with a jury in a civil trial. Lastly, if one legal action is proceeding under the simplified procedure pursuant of Rule 76 of the Rules of Civil Procedure, and the other legal action is an ordinary action, then the court must carefully balance the principles of Rule 6 and Rule 76 prior to exercising its discretion. Some of the applicable factors considered by a court in ultimately deciding whether or not it should grant an order to either consolidate legal actions or have them heard together are as follows. The extent to which the issues in each action are interwoven, whether the same damages are sought in both actions, in whole or in part, whether damages overlap and whether a global assessment of damages is required, whether there is expected to be a significant overlap of evidence or of witnesses among the various actions, whether the parties are the same, whether the lawyers are the same, whether there is a risk of inconsistent findings or judgment if the actions are not joined, whether the issues in one action are relatively straightforward compared to the complexity of the other actions, whether a decision in one action, if kept separate and tried first, would likely put an end to the other actions or significantly narrow the issues for the other actions or significantly increase the likelihood of settlement, the litigation status of each action, whether there is a jury notice in one or more but not all of the actions, whether if the actions are combined, certain interlocutory steps not yet taken in some of the actions, such as examinations for discovery, may be avoided by relying on transcripts from the more advanced action. the timing of the motion, and the possibility of delay, whether any of the parties will save costs or alternatively have their costs increase if the actions are tried together, any advantage or prejudice the parties are likely to experience if the actions are kept separate or if they are to be tried together, whether a trial together of all of the actions will result in undue procedural complexities that cannot easily be dealt with by the trial judge, and whether the motion is brought on consent or over the objection of one or more parties. In regards to weighing efficiencies and the fairness of granting an order to either consolidate legal actions or have them heard together, a court will also consider the following factors: the extent of the difference or commonality of the facts or issues in the proceedings, the status of the progress of the several proceedings, and the convenience or inconvenience in terms of time, money, due process, and administration of bringing the proceedings together. I now want to briefly discuss a motion in a 2020 case entitled Paterson and Stewart Title Guaranty Company, where the preliminary issue in this motion was which linkage option the court should favor, consolidation or hearing together. As such, this case provides some further guidance as to what factors the court might consider when faced with a debate about whether to consolidate proceedings or to order them tried together. As again, jurisprudence is not particularly helpful. So the plaintiffs, Jade and Scott Paterson, commenced two legal actions arising out of the same set of circumstances. The defendant, Stewart Title Guaranty Company, sought an order consolidating the proceedings. The plaintiffs, joined by two of the defendants in the companion action, objected. They wanted to see the court's resources used as efficiently as possible, but they resisted consolidation. They were agreeable to linking the actions together, but they favored an order that the actions be heard together or one after the other. The Honorable Justice Boswell ultimately found that the two actions should be ordered tried together. He also found that there should be certain directions to avoid unnecessary cost and to promote trial fairness. So let's now delve into this case a little more. In this case, the plaintiffs purchased a residence in Egbert, Ontario, in February of 2017 for $875,000. The purchase closed on May 23, 2017. At the time of closing, they purchased title insurance from Stewart Title with a policy amount equal to their purchase price. According to the Patersons, they discovered structural problems with the property shortly after closing. They also discovered that certain renovations had been done to the property without building permits. They claimed to have incurred significant expenses remediating defects. They alleged that the property was unmarketable. On May 16, 2019, the plaintiffs commenced two legal actions. In the first legal action, they claimed $875,000 against Stewart Title for a breach of contract. They claimed that they were entitled to indemnity under their title insurance policy for the cost of remediation. Stewart Title argued that any losses they may have suffered were not covered by their policy. In the second legal action, the plaintiffs sued 5 parties: the vendors of the property, a home inspector who inspected the home prior to their purchase of it, the township of R.S.O, where the property was located, a company who installed a roofing system they claimed was defective, and a company that insulated the attic. They also sought damages in the amount of $875,000 in this second legal action. The first legal action against Stewart Title was of a different nature than the claims advanced in the second legal action, but there were a number of issues in common. In particular, the evidence regarding the specifics of the purchase, the inspection, the closing, the subsequent discovery of defects, the origin and cause of the defects, and the cost of remediation were common to both proceedings. So the aspiration of efficiency strongly supported the joining of the two legal actions in some manner. More specifically, Stewart Title pointed out certain allegations in its defense that raised common issues between the two legal actions. In examining the legal framework, the Honorable Justice Boswell noted that it was immediately apparent that Rule 6 has certain gateway criteria, which I covered earlier in my discussion of the subrules, that must be satisfied before a motions judge may grant an order linking proceedings together. In this case, Justice Boswell noted that there were no serious dispute about the satisfaction of the gateway criteria. There were undoubtedly facts in common across the two legal actions. Moreover, the relief requested in each legal action arose out of the same series of transactions or occurrences. What was at issue in this motion was, again, which linkage option the court should favor: consolidation or hearing together. Justice Boswell provided us with some guidance as to what factors the court might consider when faced with a debate about whether to consolidate proceedings or to order them tried together. He acknowledged what I've stated earlier, that both of the proposed means of linking the actions in issue here are capable of satisfying the purposes of Rule 6, but that they achieve their common goal in slightly different ways. He noted that Rule 6 provides different mechanisms to link actions together, where doing so would avoid a multiplicity of proceedings and promote the goals of efficiency, expediency, and cost effectiveness. Orders for consolidation, hearing together, or hearing consecutively are simply three different tools available at the court's discretion to achieve those goals. Which one, if any, that's utilized depends on the prevailing circumstances. One mechanism is not inherently better or worse than the others. Whichever best serves the aspirations of the rule in the given circumstances is to be favored. From the court's point of view, either means of linkage will do, but one must prevail. The court's task is to weigh and balance the costs and benefits of each mechanism. As an important side note, Justice Boswell did not accept that there is any form of elevated onus on a party seeking an order for consolidation as compared to a party seeking an order that actions be heard together, because the plain wording of Rule 6 does not support the imposition of such an onus. In Justice Boswell's view, where there are two potential means of achieving the same goal, the choice between them must be guided by a cost-benefit analysis. In other words, where, like in the Paterson and Stewart Title case, the parties agree that the proceedings should be linked in one way or another, but cannot agree on whether they should be consolidated or heard together, the task of the court is simple. Quote, "The court must assess the salient factors that point both towards and away from an order of consolidation. Next, the court must assess the salient factors that point both towards and away from an order that the actions be heard together. Finally, the court must balance all of those salient factors to determine which linkage order will best promote the most efficient, expeditious, and least expensive resolution of the disputes." End quote. Justice Boswell went on to consider the costs and benefits of the two options on the table. In regards to the cost-benefits analysis of consolidation, Justice Boswell noted it provides the ultimate reduction in proceedings. Again, it compresses two actions into one. It provides for one set of pleadings, one set of discoveries, a common pretrial and a single trial, with no prospect of inconsistent findings. It avoids potential for the two actions to proceed at different paces. It gathers all parties with potential liability to the plaintiffs at the same table and allows for a comprehensive ruling that identifies those liable and explains why. Justice Boswell also noted downsides to a consolidation order. He noted that it will require the redrafting of double-digit pleadings. For example, in the Paterson and Stewart Title case, there were 9 pleadings filed in the tort action alone. So there will obviously be a cost associated with that effort. However, more significantly, in Justice Boswell's view, was the concern raised by the plaintiffs and vendors that Stewart Title was intent on raising cross-claims against the defendants in the tort action. If they did so, it would trigger motions by a number of parties to strike those claims. So significant additional costs, not to mention delays, would have been incurred in connection with the inevitable pleadings dispute. In regards to the cost-benefit analysis of hearing together, Justice Boswell noted that in order that the actions be heard together will also meet the goal of avoiding a multiplicity of proceedings. It would guard against inconsistent findings, and like consolidation, it would have the benefit of gathering all parties of potential liability to the plaintiffs at the same table. Justice Boswell noted, however, that unlike a consolidation order, in order that the actions be heard together or one after the other, would not implicitly provide for one set of pleadings, one set of discoveries, one pretrial, and one trial. It would not implicitly provide for the sharing of evidence among all parties to the two actions. And it would not guard against the risk that the two actions proceed at different paces. Having said that, Justice Boswell noted that Rule 6 provides him with sufficient discretion to make ancillary orders that will attenuate each of the shortcomings associated with an order that the legal actions be heard together. Lastly, Justice Boswell noted that in order that the legal actions be heard together would avoid the necessity of redrafting pleadings, and it would avoid the inevitable pleadings motions he identified with the option of consolidation. After conducting the cost-benefits analysis associated with both options, Justice Boswell noted that there wasn't much to distinguish between the two competing orders, because each would, by and large, achieve the same result. He stated that if it were not for the dispute about Stewart Title's right to advance cross-claims against the alleged tortfeasors, he might have favored consolidation. However, since the dispute had the potential to cause significant cost and delay, it tipped the balance on the motion in favor of an order that the actions be heard together, or one after the other. So as a result, Justice Boswell concluded, by a narrow margin, that the following orders best serve the goals of efficiency, expediency, cost-effectiveness, and fairness. 1, the action and the tort action will be linked. 2, the linked actions would have common examinations for discovery. 3, a common pretrial will be held. And 4, the legal actions would be tried together, either simultaneously or one after the other, in the discretion of the trial judge. Therefore, in summary, when what's at issue in a Rule 6 motion is which linkage option the court should favor, consolidation or hearing together, the court's task is to weigh and balance the costs and benefits of each of the three mechanisms: consolidation, hearing together, or hearing consecutively. These three mechanisms are merely three different tools available at the court's discretion to achieve the goals of efficiency, expediency, cost-effectiveness, and fairness, as well as avoiding a multiplicity of proceedings. One mechanism, however, is not inherently better or worse than the other two mechanisms. Whichever one best serves the aspirations of Rule 6 in the given prevailing circumstances is to be favored. I hope you found this information valuable. If you want more information, then please read my blog called "What is the Difference Between Consolidating Two Tort Actions Together and Either Hearing Them Together or One After the Other." In my blog, I take a deep dive into what factors the court might consider when faced with a debate about whether to consolidate proceedings or to order them tried together or one after the other. I also provide links to other blogs such as "What are the steps to a tort lawsuit for personal injuries?" and "What damage awards do I get from a successful tort action?" which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs with valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you.
And I'll see you soon in the 6th episode of Season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.